If USCIS is unsatisfied with your response, your adjustment of status gets denied. And if you're not in legal status, when your adjustment of status gets denied, you're gonna end up getting a notice to appear in immigration court and then end up getting being placed into removal proceedings. Hey guys, today I want to talk about the 5 top reasons that adjustment of status applications are getting denied during the Trump administration. And I'm making this video in September 2025. So if you watch this video much later, some of these things may have changed. Some of the things I'm going to talk about in this video are recent policy changes, and they might be outdated in the very near future. But anyway, let's get started. So the number one mistake I see people make is with the affidavit of support. I've done multiple videos on this exact topic, so I'm going to keep it very short. If you receive a request for evidence on your affidavit of support, you must speak with a lawyer. If you do it yourself, you're taking a huge gamble because you only get one opportunity to fix it, and the request for evidence that you get saying that your affidavit of support is defective is complete garbage. They don't explain what the actual problem is. They just restate what all of the rules are for the affidavit of support, and they tell you you're not in compliance, but you have no idea what the actual issue is. So if you get to that point, you only get one chance to respond correctly. If USCIS is unsatisfied with your response, your adjustment of status gets denied. And if you're not in legal status, when your adjustment of status gets denied, you're going to end up getting a notice to appear in immigration court and then end up getting, being placed into removal proceedings. So it's cheaper, all things considered, to hire a lawyer at that point to assist you with your affidavit of support request for evidence response. The second issue I see some people make, and it really upsets me because this is like totally avoidable if you just prepared or watched a couple YouTube videos on how to prepare for these marriage-based adjustment of status, is USCIS is unsatisfied that you're in a good faith marriage, which usually just means you didn't submit enough evidence. I see a lot of people trying to do these cases by themselves, and they think that all they need to submit is some bank statements and some photographs, show up to the interview, and everything will be fine. And admittedly, it's usually the US citizen spouse who's not worried at all about this adjustment of status process. That's probably not enough for most adjustment of status applicants. I have seen cases get approved with just photographs and bank statements, but that's taking a huge gamble, and I would submit way more evidence to overwhelm the USCIS officer with proof that you're in a good faith marriage, because that's the easiest part of getting these cases approved, in my opinion. The third reason I see adjustment of status applications getting denied, and actually also people getting detained at their USCIS interviews as of September 2025, is criminal issues and old removal orders that they didn't know about. So if you entered the US a while ago, or you entered as a child, and there's any chance that your family members, like your parents, applied for asylum, there's a decent chance you were included on that asylum application. And if your parents were not granted asylum and their application was denied, there's like a really high probability, like 99% chance, they were later placed into removal proceedings. And if you were included on that asylum application, you were probably also placed into removal proceedings. But you might not know about this, your family might not have told you about it, they might not even know about it. In those situations, it's really good idea to do a Freedom of Information Act request, but to do so, you generally need your alien number. So you might need to do multiple records requests. You might need to start by getting fingerprinted, send out something referred to as an Office of Biometric and Information Management FOIA, an OBIM FOIA request with your fingerprints, find out what your alien numbers are, and then do additional FOIA requests with USCIS or the immigration court to see if there are any records with your information on them. If you're sure that you were never placed into removal proceedings, or you're sure that you were never charged with any crimes, as most people are, then this isn't something to worry about. But if you're not sure, you don't want to find out when you show up to your green card interview. The fourth way that people are getting their green card applications denied is errors omissions, and just not submitting the correct documents. So I recently consulted with somebody who got their green card application denied without a request for evidence because they failed to sign one of the forms that were submitted with the adjustment of status filing. Historically, that would never happen. USCIS would just send you a request for evidence asking you to fix that one page, and then they'll continue processing your application. But there was recent guidance indicating that USCIS does not have to issue a request for evidence. So if you get a bad officer, especially before this case gets transferred to your local USCIS office, if it's being processed at a service center, one of the many processing centers throughout the United States, your application could get denied if you don't submit the correct information, don't submit every page of every application, miss a signature. There are many signature pages. After this started happening, we implemented new procedures in my office where we need to manually number each page and make sure a page isn't omitted. You know, our printer sometimes messes up when we go to scan stuff gets jammed. If a single page is not submitted with a client's adjustment of status application, we risk losing the entire government filing fee and our client being placed into deportation proceedings. So the risks have never been higher, and I'm constantly on edge because of this. And if you're submitting an adjustment of status application, just keep all of this in mind. The final mistake I see a lot of people making, especially the people who were paroled into the US under the Biden humanitarian programs and other programs historically, is filing an I-130 through a preference category petition, believing that once that I-130 gets approved, that they could apply for adjustment of status. That's usually not the case unless you maintain some sort of valid non-immigrant visa status the entire time. I just did a video where at the end I discussed someone in the US on a student visa can marry a permanent resident and apply for adjustment of status, but it's a multi-step process and they need to maintain valid student visa status the entire time. They cannot be out of status if they're marrying a permanent resident, whereas they could be out of status if they were marrying a US citizen. And with a US citizen, they could file all the forms at once. It's called a concurrent filing, otherwise known as a one-step adjustment of status. But if your I-130 was filed by your parent and you're an adult, whether you're married or unmarried, or it was filed by your sibling, or you're filing, the person who filed the petition was a permanent resident, those are not immediate relative petitions. You need to maintain valid non-immigrant status the entire time you're in the US. So if you're already out of status, your parole expired, your TPS expired, your student visa or tourist visa expired, you cannot apply for adjustment of status through those categories unless you qualify for one of the rare exceptions. If that's you, talk to an attorney before you file your I-485 adjustment of status application, because there's a very good chance that your adjustment of status will get denied and you will receive a notice to appear to begin your deportation proceedings. All right, guys, so that's a summary of the 5 top ways I see people getting their adjustment of status applications denied. Just a reminder, if it gets denied and you are not in some other sort of valid immigration status, you should be placed into deportation proceedings under recent USCIS policy guidelines. And if you don't, it just may not have happened yet, or you may have gotten lucky, but it could take 6 months or longer before that happens. So just be aware. If you're applying for adjustment of status or you want guidance from an attorney, even if you plan to do it yourself, I can do it for you, or I can guide you along the way if you just have some questions. Schedule a consultation directly with me. My information is in the video description below. You could just click the link and book a consultation. It takes like 5 minutes. I handle these cases nationwide, and I do everything from just guidance where I answer specific questions to filing the whole thing for you from start to finish so you don't have to worry or think about it. All right, guys, that's it for today. I'll see you next time for another video.